Hello, this is Dr. Danielle with a Q&A session. The question is, what is considered reasonable accommodation? Let's look at the answer. What does it mean to be reasonable? What does the law say? Accommodations are variations in the way things are normally done to enable individuals with disabilities to have an equal opportunity to participate in court activities. Government entity is not required to fundamentally alter the program or service for which the person with a disability is requesting an accommodation. First, let's see what needs to be demonstrated. Well, an evidence of disability. Without an evidence of disability, you're not going to get much in ways of accommodation. And how it affects your ability to access court proceedings. What accommodation you're requesting, and process is unfortunately different from state to state. So having a trained and certified advocate makes the process easier. Let's see about accommodations for physical impairment. Now you would imagine that people in a wheelchair, it's quite obvious that they have a disability. Well, it was not always the case. There was a case in Tennessee where the person with a wheelchair had to climb on his hands to the second floor. There was a lawsuit and things have changed since then. Because it was violating Title II of the American with Disabilities Act. Under Title II, no one can be denied access to public services due to his or her disability. It allows those whose rights have been violated to sue states for money damages. So it would be unreasonable to require that a court build an elevator if you have a wheelchair. However, reasonably, you can have access to a courtroom which is on the first floor or another building if it's necessary. You have to make your request quite well known in advance so that the courtroom can be vacated that's on the first floor or that they can make accommodations in a different building. And if you work with an advocate who is local, he or she can check for potential challenges ahead of time. He or she can go visit the courts, the room that they are being assigned to you, check the access to the bathrooms if need be, and report what would be a challenge. Now you would think those things are quite obvious. I mean, restaurants do accommodate, hotels do accommodate. The courts haven't caught up with accommodations quite yet. There's another physical impairment, people who are deaf or mute or have a problem with language. Besides wheelchair access, courts can now provide interpreters for people with hearing or speaking disabilities. It's unreasonable to demand that the judge or the whole court personnel learn sign language. However, reasonably, you can request an interpreter or being allowed to come to a hearing with one person who can interpret for you. If you work with an advocate, he or she file the proper paperwork and make sure your needs are being accommodated. Now, accommodations for invisible wound, it's a little bit harder. Why? Because it's invisible. If you're in a wheelchair, everybody sees that you have a disability. But what about if you have cancer, diabetes, epilepsy, asthma, chronic fatigue, fibromyalgia, Lyme disease? All those are disabilities that may hit you at some time, but not at others. Cancer, you may take the medication that can offer some disadvantages. Diabetes, you may have to get out of the hearing to get your insulin shot. Epilepsy or asthma, what if you have a crisis in that environment? Chronic fatigue, fibromyalgia, Lyme, you are tired and may need more time to understand or to file paperwork. About autism, post-traumatic stress, legal abuse syndrome, being bipolar, having schizophrenia, anxiety or panic attacks, having intellectual challenges, depression, dissociation. Again, these you don't see right away like a wheelchair, and people may not believe that you have a problem, and yet those are invisible disability that can be accommodated. So what are reasonable accommodations for invisible wounds? Well, you can request to have an advocate, a friend or family member with you to monitor for potential stress or stressors, help you prepare written documents in advance, take notes for you, organize paperwork. You can have short periods of timeouts, like 10 or 15 minutes to calm down, drink some water, eat a snack, speak with an advocate in the hallway or on the telephone, take necessary medication, use the restroom. Be allowed to use a recording device so you can review what was said and what happened in a less distressing environment. If fearful of being in the same room as an opponent, request to be seen via video conferencing from a different room or by telephone. Many courts will accommodate that. Being seated where you do not feel trapped. A bailiff standing between you and your opponent. That has happened in a court that I was working with. Have a court-trained dog. These animals are amazing, especially if children are involved. Avoid aggressive cross-examination. Be in a smaller, quieter room. And also request that you be spoken in plain English and not in legalese. So if you want to know more, you can contact us. We have an address in Colorado Springs, a website with all kinds of different videos. You can contact us by email and even by phone. And stay tuned, as we're going to have many more videos coming up.